The matter of Lawrence Rappaport versus Kenneth Pasternak. Can we please have appearances of counsel?
On behalf of today's petitioners, my co-counsel.
Alex Daniel on behalf of the Jersey City Justice Institute and Mr. Adams.
May please defer to the board from Calvin Dowlich on behalf of the Martin.
Good morning, counsel. Mr. Shu, please go ahead.
Good morning. May it please the court. And with the court's permission, I would like to reserve 3 minutes for rebuttal.
That's fine.
It is my privilege to appear before this court, even though I will argue that had the heightened standard of deference been afforded the arbitration in this case, we would not be here today. Chief Justice Valence observed that parties choose arbitration to stay out of the litigation ringer, but here we are. This case involves a contentious business breakup. We terminated plaintiff from his position from our companies, and he filed a complaint, and then we filed a counterclaim. The parties decided to resolve this case through arbitration. The parties selected an experienced and well-respected arbitrator. The parties agreed to resolve the dispute involving the claim and counterclaim and any related claims. The parties also agreed to resolve any dispute, including any claims that could be asserted by any party as part of the claim or the counterclaim, or with respect to the dissolution or disassociation of plaintiff from or plaintiff's employment with the cable companies. That was a broad charge to the arbitrator, empowering him to address not only the dissolution or disassociation of plaintiff from his employment, but also from the companies as well. The parties also conferred on the arbitrator the power to rule on his jurisdiction and the scope of the arbitration agreement or the arbitrability of any claim or counterclaim. In short, the arbitrator was also given the authority to determine whether the parties submitted a particular claim for his determination. The arbitrator reviewed 10,000 pages of documents, which included pleadings, transcripts, briefs, exhibits, and correspondence. He conducted 13 days of hearings, and he listened to additional days of oral argument. The arbitrator rendered a decision that plaintiff was wrongly terminated and awarded him $4.9 million for his membership and management interests, and held that plaintiff had failed to prove that he was entitled to carried interest. Plaintiff persisted. Twice more, the arbitrator ruled that the issue of carried interest was before him, and twice more, including after a remand, he ruled that plaintiff was not entitled to that relief. The Chancery Court affirmed the award, and then the Appellate Division reversed, applying essentially a de novo standard of review and not applying the heightened standard of deference to be afforded a private sector arbitration as required by this court's decision in Tratina. In our brief, we've pointed out numerous times when carried interest was raised by both parties during the arbitration agreement, during the arbitration proceeding. But that is not the point. The parties chose the arbitrator to decide whether the issue of carried interest was submitted for his consideration, not the Appellate Division. The parties chose the arbitrator to decide the value, if any, of the carried interest, not the Appellate Division. The only issue for review is whether the arbitrator was egregiously wrong in deciding the issue of carried interest, not whether the plaintiff or the Appellate Division has the better of the argument. We do not concede that they do, but more importantly, in our view, no fair reading of the record could lead to the conclusion that the arbitrator was egregiously wrong. A clear illustration of the danger of the Appellate Division's fact-specific review is that it wrongly claimed that the arbitrator sua sponte raised carried interest in a dialogue with plaintiff, when in truth, the colloquy was on direct examination between plaintiff and his attorney. That error was one reason the appellate division went awry. The parties here chose arbitration as a forum to stay out of the courts, not as a prelude to another round of litigation. This court in Tratina made clear that judicial intervention in a private sector arbitration should be an extremely uncommon occurrence. The reversal of the appellate division in this case will send that message. I'm now prepared to respond to any questions you may have.
Was it clear from the pleadings, and if so, can you tell us specifically where that carried interest was going to be an issue?
Specifically in the pleadings where carried interest was raised, the issue of carried interest was raised in the very first claim for relief. It was raised in multiple places, but in the first claim for relief for declaratory judgment, and this is in Appendix 1, you can find it in Plaintiff's Appendix, pages 339 to 341, he seeks declaratory relief to reverse his termination and reinstatement as an owner of the CABR entities, and he seeks monetary damages in an amount to be determined at trial.
Is there a point where there's specific reference to carried interest in the pleadings?
There's not a specific reference to carried interest in the pleading. There's a specific reference on in multiple places to compensatory damages for damages, not just in the declaratory relief claim, but in the breach of contract claim, he seeks compensatory damages for breach of the CABR operating agreements. He alleges that those operating agreements allowed no change in the compensation to any of the partners, and he alleged that Pasternak and the other defendants engaged in a systematic campaign to circumvent his interests in CABR as both a member, chief executive officer, and a manager. In his breach of fiduciary duty claim, he raises the similar allegations, and in specific, in his minority oppression claim, he specifically claims that compensatory damages for conduct that allegedly was deliberately designed to deprive him of the value of his membership interest in the CABR entities. And that's at PA 374 to 376, paragraph 332. And I'll acknowledge he did not use the words carried interest, but he testified on direct at the hearing that carried interest was encompassed within profits and losses under the operating agreement. And that's at Plaintiff's Appendix at page 2075. So it's no different than the management fees than carried interest. They're both the same. They're both compensatory damages that plaintiff was seeking. And the argument now is that nobody sought carried interest. Well, carried interest is a performance fee, rewarding the CABR management for doing a good job and profitably managing their investments. In plaintiff's post-hearing brief, he devotes half a page to the definition of carried interest. That's at page, it's in a glossary, it's on page PA 1129 of plaintiff's appendix. We defined it in our post-hearing brief at page 1319. So the issue is clearly presented in the pleading, we believe, and I can also give you examples from the record itself where the claim was specifically raised.
The operating agreements had an arbitration provision, and then later the parties negotiated an arbitration agreement. Am I correct about that?
That's correct.
And the definition of the scope of the arbitration is not between those two documents or two agreements, it's not absolutely identical. Should we assume that the scope of the arbitration as stated in the arbitration agreement superseded the earlier operating agreements language or arbitration clause in the operating agreements?
Yes, and the arbitration agreement expressly says so towards the back end of the arbitration agreement. It says that it was a very heavily negotiated agreement after plaintiff filed the lawsuit in the Chancery Court.
Yep.
We moved to compel arbitration. The parties then stipulated to dismiss the action and heavily negotiated an arbitration agreement with a very broad clause.
So when we're looking for the scope, the parties agreed upon scope of the arbitration, we should look to the arbitration agreement?
You should look to the arbitration agreement. And what I will say is that in plaintiff's supplemental brief, there's an argument in section 3, pages 35 to 43, where plaintiff argues, and this is contrary to the finding that the Appellate Division itself made, that the claims were within the scope of the arbitration agreement. But plaintiff argues that the broad whereas clause in the arbitration agreement, which is at PA 197, for the court's reference, the argument is that, well, we're relying, because we quoted, I think, in our brief, the whereas clause, which has that very broad language in it. And plaintiff argues that that's a prefatory whereas clause that the courts are entitled to and may disregard because it was not specifically incorporated into the arbitration agreement itself.
Let
And
me
that
ask you about the language of the scope of the arbitration clause and the arbitration agreement. And just tell us, if you would, where carried interest fits into this. It starts, the scope of the arbitration shall be confined to adjudicating the claim, counterclaim, and related matters, including but not limited to. But let's just take that phrase in isolation. How does carried interest fit into, quote, the scope of the arbitration, adjudicating the claim, counterclaim, and related matter?
Okay. It falls within the claim for the reasons I discussed a few moments ago, in that plaintiff was seeking compensatory damages, which would include carried interest as lost profits under both his declaratory relief claim, his breach of contract claim, his breach of fiduciary duty claim, and his minority oppression claim. It also fits within the counterclaim because in defendant's counterclaim, we specifically requested at the end declaratory relief that plaintiff has been or may be terminated from all the CABR entities and entitled to no further compensation. That's the counterclaim. And any related matters would be, to the extent that you argued that it's not, that doesn't fall directly within the claim or the counterclaim, it would certainly be a related matter. But the clause goes on and continues.
And I was about to ask you about that. It next says Rappaport's request for injunctive relief under the order to show cause. Does carried interest fit into, and this is all within an including but not limited clause. So it states the claim, counterclaim, related matters, and then it says including but not limited to. So here are the specific items that it's including in that clause. One is Rappaport's request for injunctive relief pursuant to the order to show cause. Does carried interest fit into that?
It does not fit within the first line of the injunctive relief. That was for a different matter, but it would fall within the next clause, which would be any claims that could be asserted by any party as part of the claim or the counterclaim.
So I wanted to ask you then as to that, so we can just ignore that language, the order to show cause. But then the next one appears to be claims that were not asserted directly in the claim and counterclaim, but could have been with respect to the dissolution or dissociation of Rappaport or his employment with KABR entities. Are there, in addition to the role of carried interest in the claims and the counterclaims that you've already discussed and you discussed in your brief, are there claims that could have been asserted in the claim or counterclaim as to which carried interest is a part? See what I'm saying? Is there a broader universe of claims that would fit into that last clause in the paragraph?
Well, first I would note that that's the second to last clause of the paragraph.
I'm sorry.
I'll point out the distinction in a moment.
Yep.
But to answer your direct question,
You know it better than I, clearly.
I think what I would say is anything that plaintiff is claiming was not raised, but was maybe partially raised or related to the prior claims would fall within that clause. And keep in mind, at the time that this arbitration agreement was entered into, we hadn't yet filed the counterclaim. It was simply described as any claim that we could bring against the plaintiff. So the intention of the parties was to litigate anything and everything, anything related, any related matter to the claim or counterclaim, anything that could have been included within the claim or the counterclaim. Now, we think carried interest was included within the claims. To the extent that the argument is that it was not, well, it could have been. So it's also included within that clause as well.
So you could have brought a counterclaim that said he's not entitled to carried interest.
We think we did by saying that he's not entitled to any further compensation. And again, we were not required to file a pleading under the AAA rules. Anything that we didn't respond to was deemed denied under the AAA commercial arbitration rules. So we didn't. Now, we could have filed a full counterclaim plaintiff filed, I think, a 75-page complaint. We filed, I think, a 8-page counterclaim with multiple claims. But we could have sought a formal declaration and determination that his interests had been redeemed, canceled. We could have brought an action under the explicit claims, counterclaims under the Revised Uniform Limited Liability Company Act to dissolve the company, to expel him from the company. We could have filed any number of claims that would be related to the claim or the counterclaim. But we didn't feel the need to, specifically because the arbitration agreement, if you look at the next clause, it says after that, or with respect to the dissolution or disassociation of Rappaport from the Caber management companies. So the disassociation of Rappaport from the Caber companies would require, as the Appellate Division found, the valuation of his interest, including his claim, his quote, membership right to carried interest.
So you're saying there are three different ways in which carried interest is implicated in this paragraph. Pretty much everything in that paragraph except the reference to the order to show cause.
That's correct. I think it's 5, not 3, but I won't quibble.
Oh, okay, my counsel.
I won't quibble with you.
Okay.
Counselor, on 14th day of the arbitration hearing, so I'm looking at page 3108, you say, talk for a moment about damages because Your Honor asked a question about that. Our position is that Mr. Rappaport is not entitled to any damages, no lost income, no carried interest, because he breached the contracts and he was properly terminated with cause. Now, the arbitrator, who you rely very heavily upon, found that he was not terminated with cause. Doesn't that kick the platform out from the foundation, or does that remove the foundation of this argument? And so if you're saying he's not entitled to carried interest because he wasn't terminated, because he was terminated for cause, and the arbitrator says, no, he was not terminated for cause, doesn't that mean then, isn't the converse that therefore he is then entitled to carried interest?
It does not, for several reasons, but the first one that jumps immediately to my mind is that even if you were entitled to carried interest, you still have to prove what it is and how much you're entitled to. One of the grounds for the arbitrator's decision was that he did not prove what the value was of the carried interest. It's simply a failure of proof. Okay, you're entitled to carried interest, but you didn't prove it. You didn't prove what it was. It could have been 25 million. It could have been 14 million. It could have been 0.
Is your point then that even when the arbitrator asked for supplemental briefing on the carried interest issue, that Mr. Rappaport or his attorney could have submitted a valuation, could have submitted an expert report, even at that time, that would have provided some basis for a more in-depth understanding of what the value was, other than this sort of $25 million that seems to come out of the air? Is that what your point is?
Absolutely. He could have presented that evidence at any time. This arbitrator went out of his way to allow the parties 13 days of arbitration testimony, multiple witnesses, expert witnesses. We didn't call an expert witness. Our clients are experts in real estate and real estate valuation. I would venture to say that Mr. Rappaport was an expert in real estate. Maybe he didn't want to pay for another expert opinion. Maybe he got an expert opinion and he didn't like it. Maybe he wanted to receive carried interest in perpetuity and he didn't want to put a fixed number on it. The point is, the claim was submitted. And I don't think this court, and certainly the Appellate Division, should have been second guessing the arbitrator's determination as to whether carried interest was submitted or what the value of it should be. Remember, in the arbitrator's second decision, and it's hard to keep track because there were so many little pieces, but in his second decision on carried interest, he granted reconsideration of the request for carried interest. And he said, you're not entitled to this for several reasons, not just the one that Your Honor mentioned before, but you're not entitled to it. You haven't proven the value of it. And even if I were going to give you some carried interest, it would be de minimis. And he emphasized in his first ruling, he says, I emphasize I am making my own independent assessment of damages. So that should have been case closed. The arbitrator was empowered under the arbitration agreement, under Rule 47 of the AAA rules, and under the New Jersey Arbitration Act to make any award that he felt was just and equitable under the circumstances, as long as it was in the scope of the arbitration agreement. Carried interest was in the scope of the arbitration agreement. He issued an award on it, and the award is not obviously or egregiously mistaken.
What was your
Under-
reference to the AAA rule? I missed that. What number
Rule
rule?
47,
It is a bit
Rule
puzzling.
47?
47.
Oh, I thought we had been referencing section 7A of the commercial arbitration rules.
Section 7A is the reference to the AAA rule that says the arbitrator has the right to rule on on his own jurisdiction and any objections to the scope
Okay.
of the arbitration.
It is a bit puzzling that in a case like this, with sophisticated parties and an extensive hearing and capable attorneys, that, as you point out, there was no proof of valuation. You've given us one reason, and I don't expect your answer is going to deviate from that, and that is that it was simply a failure of proof for one reason or another. Is there perhaps another reason, and I'd like to hear your response? Is it perhaps an indication that it wasn't quite so clear at the outset of this arbitration that carried interest was a part of it? How would you respond to that?
What I would say is this. Carried interest, again, by definition, was within the scope of the claim as originally filed. Okay, the breach of contract claim, the arbitration claim, breach of fiduciary duty claim, it was there in the complaint. Okay,
They're in the complaint in the form of the compensatory damages
Correct.
request,
correct.
but not clearly stated as carried
Not
interest.
explicitly stated as carried interest. Okay, but then, and I think, perhaps, to your Honor's question, at some point it became an express issue. The motion in limine that plaintiff filed shortly before the evidentiary hearing began, specifically requested declaratory relief that he was entitled to the same things that he set forth in his complaint, including the carried interest that he would otherwise be entitled to. So I don't know if it was discussions between the parties or the filings. Plaintiff testified that he was on notice from our pre-hearing brief that we were contesting his right to carried interest. And that is why he testified on direct examination. He said, with respect to this arbitration, are you asserting any claims with respect to your carried interest? I'm asserting the fact that I'm entitled to that and I am fully vested in it. And I value it at $25 million.
And
Now-
what's the site on that one again?
That is in the record at both PA 1440 and I think 1029, but it's definitely at 1440. And in a closing argument, his counsel stated, Mr. Rappaport is entitled to the profits and loss of the management companies, including the carried interest. We ask there be a full award of all future carried interests. This is a closing argument at PA 1101 and 1104. We are going to do a detailed damages calculation with a chart. His carried interest, again, if he were deprived of that, that's nearly 20 or more million dollars. And then in his post-hearing brief, they set forth the chart and they dropped the footnote and said, should he no longer continue as a member, the value of his carried interest is $25 million. And that would be in addition to the $44 million outlined supra for a total damage award of more than $69 million. In plaintiff's proposed form or order and award, which he submitted to the arbitrator, he specifically requested, and this is in the appendix, sorry if I'm speaking too quickly, at PA 1239, in paragraph 3E, plaintiff, quote, is entitled to the carried interest paid from the CABR funds to the corresponding CABR management entity to the claimant and respondents in the proportions set forth in the CABR operating agreements. And in his motion for reconsideration, claimant seeks clarification to confirm that the interim award's reference to carried interest ensures claimant's ongoing rights to receive carried interest when, if ever, it is distributed in accordance with the operating agreements.
But you pointed out that plaintiff asserted that right even before the arbitration. So it can't be that the arbitrator himself unfairly injected this issue into the case, because in his motion in limine that was submitted before there was any testimony, he requests this declaratory judgment or declaratory relief that he's a fully vested member of KABR under the operating agreement and is entitled to future carry regardless of whether he remains a manager or not.
That's 100% correct. And I would also note that not only did the arbitrator not inject the issue of carried interest into the proceeding, I believe he took into account the concern that plaintiff raised, and I'm assuming some of your honors may have, with regard to how fully it was raised. And he requested and directed the parties to brief in the post-hearing brief whether it was adequately raised, not whether it was raised. It was clear to all of us that the issue was submitted. The question then became, well, plaintiff's objecting and saying you shouldn't consider this. And we each submitted a whole section of our post-hearing brief to whether plaintiff's due process rights were violated by litigating this issue, which was not expressly mentioned in the complaint.
So can plaintiff's argument be that he wasn't required to show any kind of valuation because all he was requesting was to continue to receive the carried interest as set forth in the operating agreements? And so the way this works is every time there's a sale, then the members are entitled to a certain amount of carried interest. At the time of the arbitration, there hadn't been any sales. And as you pointed out, I guess the value of certain items of real estate can be contested. So it was plaintiff's claim here, all he wanted was a declaration that he was entitled to carried interest in the future. He had no obligation to prove how much that was because it varies after every sale. There's a different amount of carried interest that the members are entitled to receive.
I think I would say that was his choice. That was his election. I wouldn't say that he was not obligated to do that. When you seek damages for breach of contract,
said you wouldn't say he's not obligated to do it?
I would not say that he's not obligated. He is obligated to do that.
But why? If he didn't want to actually get the money right then, all he wanted was to continue getting the money every time the carried interest was paid out in whatever proportion he was entitled to, because he had these agreements that set forth the amount he was entitled to. Why did he have to prove up front how much that would be worth in future years, rather than just getting this declaratory judgment that in future years, when there were these payouts, he too would receive them?
Because when a party files an action for minority oppression under the Revised Uniform Limited Liability Company Act, it triggers the right of the court or an arbitrator to issue an award other than dissolution, including expulsion of the member and valuation of his or her interest in the company. You don't have a guarantee that you're going to win on your right to receive carried interest payments in perpetuity as a continuing member of the company. So you have to put a number on it.
Saying, sorry, that you can only get carried interest in perpetuity if you remain a member of the company.
Sure.
And therefore he needed to at least argue that in the alternative, if he were not to remain a member of the company, then his rights would be valued at X on X day.
That's correct. That's correct. And that's exactly what he did.
So following up on Justice Wayne-Raptor's question, are you saying that he is, by filing this ROLCA claim, he was essentially raising an issue that could end up with the alternative remedies under ROLCA, and one of those alternative remedies would in fact require the valuation of his carried interest?
100%. The claim was ripe as soon as he filed. I would argue, not just the minority oppression claim under the ROLCA, but also the other claims for compensatory damages under his other claims. The Arbitration Act provides that the arbitrator can conduct an arbitration in such a manner as the arbitrator considers appropriate for a fair and expeditious disposition of the proceeding. There's nothing in the Act, and there's nothing in the Revised Uniform Limited Liability Company Act that requires a bifurcated hearing or two lawsuits, one first on your right to membership and then another on your valuation. I mean, the whole public policy of avoiding piecemeal litigation would be undermined if this court would to adopt that or sanction that as a rule.
Can
We
you,
think- go
can
ahead.
you prevail in this case if the court does not include as part of its analysis that the failure to provide the expert with evaluation is fatal to plaintiff's claims? In other words, can you prevail based upon the language of the agreement and the interaction and the communications between the arbitrator and the parties regarding this issue as to whether it was included in the arbitration?
If I'm understanding your question correctly, I think the answer is that where you have a broad arbitration agreement that includes anything and everything that the parties were going to litigate regarding the value and their rights to receive compensation from the company, when you agree to that, you're bound by the decision of the arbitrator, as long as he or she does not go off the rails. That's what Tratina says.
And you're specifically relying on this court's adoption in Tratina of the Chief Justice's concurring opinion in Perini, where he says that arbitration awards are, quote, final, not subject to judicial review, absent fraud, corruption, or similar wrongdoing on the part of arbitrators. And then, quote, whether the arbitrators commit errors of law or errors of fact should be totally irrelevant. The only questions are, were the arbitrators honest? And did they stay within the bounds of the arbitration agreement?
Yes, I rely on that language. I also rely on the fact that Justice Willens quoted the language, the modification language of the statute. And he says, look, if the arbitrator rules on a matter not submitted, he says, in other words, when arbitrators decide something that no one asked them to decide, unless they had to do so in order to decide that which was submitted. And when he refers to a matter not being submitted, he says, if the arbitrators decide a matter not even submitted to them. I mean, the language of his opinion, I think, is extremely clear that this is a very narrow grounds for modification or reversal.
Are there any constraints on the arbitrator's authority to determine the arbitrability, a word I've long struggled to pronounce correctly? I think I might have gotten it right that time.
You and me both.
Great.
Thank you, Chief. Of a particular issue. See what I'm saying? Are there any constraints? The arbitrator obviously has authority under this agreement and certainly under the Perini concurrence and Trantina to make a determination of arbitrability. But is that infinite, or does that have constraints on it?
I would say it's absolute when the parties agree that it should be absolute. Now, the court would still have a heightened standard of deference, but there still would be a review. There would still be appellate review to determine if there was serious wrongdoing or an obvious egregious mistake. So take the Block versus Plosia case, for example, that's cited in plaintiff's brief. If you are arbitrating and you have a broad arbitration clause and you're seeking breach of contract, and the arbitrator awards damages for breach of a consumer fraud statute that the parties didn't even mention, didn't even know existed until they read the arbitrator's decision, that would be something that's outside the scope of the arbitrator's power. So you can issue a ruling as to what's arbitratable, and I'm sure if I got that right, but I don't know that it's infinite, and it's certainly subject to review.
And does that fall into, if we're talking about the statute, where specifically in NJSA 2A:23B-23, where specifically are you finding that review? Is that number 4, the arbitrator exceeded the arbitrator's powers? This is just talking about a court shall vacate an arbitration when, and then it lists 6 different times when. And I didn't see one where it says, the arbitrator clearly got something wrong. You keep saying that if the arbitrator clearly gets something wrong, then there can be court review. I don't see that in the statute, but I do see an arbitrator exceeded the arbitrator's powers. Is that a statutory hook?
The language that I'm using for my argument is from the language from Justice Willens's concurring opinion in Perini, which Your Honor read from before, where he says, how do we construe this? What are the bounds? Is it undue means? Is it reasonably debatable? Is it clear error? Is it serious error? And he raised all of those issues. And he says it has to be something when you're talking about whether the arbitrator exceeded his authority, which was the issue at the prong at issue that he was discussing there in Perini. that it had to be fraud, corruption, serious wrongdoing. When it comes to the other section, 24, it was section 9 in Perini, 9B, which is the one we're talking about, a matter not submitted to the arbitrator. He says it has to be something that no one asked the arbitrator to do and clearly outside the scope.
And as to modification, doesn't that also, quote, have to be corrected without affecting the merits of the decision upon the claim submitted? At least in the statute, it says when you're talking about modification, you can modify if the arbitrator made an award on a claim not submitted to the arbitrator, and the award may be corrected without affecting the merits of the decision upon the claim submitted.
Correct. And that, so an example of that would be in Block versus Plosio, where you had an award for $30,000 and the arbitrator tripled it, gave treble damages under the statute, so it became a $120,000 award, right? So there you could excise the treble damage and without doing an injustice to the award, without affecting the merits of the award. Here, you can't do that. You can't modify where the arbitrator issues a combined award for management and membership interests of $4.9 million. Remember, he says, I made an independent assessment of damages, and I think 4.9 on remand, he says, it was specifically my intention to award $4.9 million in damages for his management and membership interests. So now the Appellate Division said, we're gonna modify the award in part to cut it in half, but we don't actually know if it's half or some other fraction. And we're going to let it stand just for management fees, not for the management interest. The statute says you can't do that. And what I would say is, with regard to the Appellate Division's error, this is at least the third time that this issue has presented itself, right? It presented itself in Perini, where the courts below were concerned with the arbitrator's award, very high award for lost profits, right? Delayed damages in connection with the delivery of the property. It was an issue in Tritino with regard to whether the arbitrator had correctly analyzed and reserved the retainage amount in his damages award. And it's an issue here again today. And it's the same error to second guess the findings of an arbitrator that are not clearly erroneous.
Counsel, you referenced Roca before, and in fact, you specifically referenced the court's expulsion authority. But if we look at Roca, what it says is that if the court exercises that authority, it can then authorize the sale of the assets so that they can be equitably distributed. So in a sense, just to boil it down to layman's terms, what the statute says is the court can say, we're authorizing expulsion, separate your balls, you are receiving expulsion, take the balls you get and go home. What you seem to be saying in this case is that go home, but you don't get to take any balls with you. As the court could authorize under its expulsion authority under Roca, that seems to me incongruous.
Well, I'm not saying that the arbitrator or a court in that situation has to say you can go home with nothing. What I'm saying is when you file that claim, you're putting at issue your interest, your membership interest, and its value. And you need to prove that value. And the parties here litigated that value. Plaintiff put in evidence concerning the value of his interest.
So what I sort of hear you to be saying is that this may not be fair, but it's their fault.
Well, I mean, I don't know that it's not fair. I think it is fair.
Well, let's talk about
I certainly would agree with you that it's their fault because they had either for strategic reasons or financial reasons or litigation reasons, whatever it might be, they decided to put in the evidence that they decided to put in. You don't get a second bite at the apple because a hearing turned out in a way that you didn't like. And I would say, just with regard to the equitable prong of plaintiff's brief at the very end, where he says that the Appellate Division could properly have modified or vacated the award on general equitable grounds. General equitable grounds is not a grounds to vacate or modify an award. And there was nothing unfair or inequitable about this award. You have a plaintiff who who was ousted from his position at this company, he was awarded $4.9 million because he didn't prove an entitlement to more money. What's unfair about that? That's how the process works. That $4.9 million, the net, I think he got, there was an offset for a counterclaim, it's $4 million in cash that he was paid 4 years ago. He doesn't have to work another day. That if he invested it in the S&P 500, it'd be worth over $6.5 million today. Keeps it there, it'll be worth over $10 million. So I don't think it's unfair what the arbitrator did. He said he made an independent assessment of damages and he awarded money for his management and membership interests. And I do agree with you that if they could have proved a higher amount and they could have had an expert do so, then they should have done that. And we didn't call an expert. And the arbitrator said, I'm ruling against you on a few of your claims because you didn't call an expert.
So soon after this, as I recall the facts, and they are extensive, I believe there was an individual named Mr. Blaustein who was a withdrawing member, right? And there was a sale of properties and he received carried interest soon after this, right? And that would have been had Mr. Rappaport not been terminated or not, then that would have been carried interest that likewise Mr. Rappaport would have received, right?
Yes.
And your point is, even though he wasn't terminated for cause, as the arbitrator held, he should not be treated the same way as Mr. Blaustein as a withdrawing member was treated.
That's correct.
Okay.
There was a different relationship between the parties.
Well, they were both entitled to carried interest. Mr. Blaustein's a withdrawing member, right? So he's no longer an active member. He's a withdrawing member. He gets carried interest. Mr. Rappaport was not terminated for cause. He doesn't get carried interest, even though he would have if he was still with the company.
I would basically agree with you, but Blaustein was not a withdrawing member. He was a continuing member.
Other questions?
He was just a passive, non-managing member.
Other questions, anyone? Thank you. Anything you'd like to add at this point?
Thank you.
We'll have you back for a vote. Mr. Daniel.
Good morning, Your Honors. May it please the court, Alex Daniel, New Jersey Civil Justice Institute. I don't know if any member of the court has ever fought with a loved one before. I did it last night. It wasn't particularly fun. First thought that came to my head, I really wish this were over. I really wish this were done. My wife and I have a rule. We don't go to bed angry. Whatever else happens, we resolve our dispute. At a certain point, Kenneth Pasternak and Lawrence Rappaport also wanted their dispute resolved. We know that because they said it in their arbitration agreement. They wanted their dispute to have final and full resolution. There's a reason why people choose arbitration. There's a reason why NJCJI is here today, and it's to protect the benefits of arbitration. Whether it's the fact that it's a low-cost vehicle for resolving disputes, relatively efficient, expedient, can be personally tailored to the needs of the party, whatever it is, all those benefits, the linchpin of it, is that there's finality. That at the end of the day, barring corruption, fraud, undue influence, or one of the other statutorily prescribed grounds, courts will ultimately respect the final determination of an arbitrator. Protecting finality in arbitration, at least in the context of the federal cases that we cite to the court and that we feel are persuasive and relevant authorities here, begins with the presumption of validity. That presumption of validity ultimately can only be rebutted, at least as far as the Third Circuit has found, when it can be said from the face of a written opinion that there was obvious error. That's it. That's where the entire process begins. And that's where we think the Appellate Division went off the rails in this case. It didn't begin with presumption of validity. It didn't begin by looking
Wait
at the
up,
face.
please. I'm missing a little bit of what you're saying.
Oh, apologies, Your Honor. Still coming up. I have kids and coming off a little bit of a sickness. The Appellate Division's analysis here didn't afford the arbitrator that presumption of validity. We have two decisions at the heart of this case. We have the initial arbitration award as it was ultimately finalized, and then we have a remand where the arbitrator was asked bluntly, were these issues put in front of you, were they within the scope of your arbitration? And he said resoundingly yes. The parties raised them, they were briefed, they were argued, testimony was taken, arguments made. they were within the scope of this arbitration. But instead of applying the presumption of validity and asking whether or not in the face of those two decisions, there was obvious and indisputable error, the Appellate Division engaged in a headlong dive into the arbitration record in this case. They found disagreement with determinations made. It supplanted fact-finding of the arbitrator on both the grounds of damages and whether the matter was properly put before them. Our federal courts instruct us time and again that when it comes to reviewing arbitration, courts have to resist the urge to engage in de novo review of the award on the merits and the record below. Now, in their supplemental briefing, plaintiff has suggested that it is a common practice in federal court to engage in a plenary review of the record. I believe those are the exact words. They cherry pick some language from Metro Media and the Brennan case, both of which we cited in our brief. And I just want to clear up this dispute that we have with that interpretation of both those cases. In both Metro Media and in Brennan, the court does make reference to plenary review. But the supplemental briefing here kind of truncated that reference. Specifically, the Third Circuit said that we begin by explaining that reviewing court decision concerning validity of arbitration or assessment of the arbitration panels governed by the same standard that governs the district court's review. We owe no deference to the district court's analysis. Instead, we exercise plenary review over the district court's decision to vacate an arbitration award. Contrary to what was stated in the supplemental briefing, courts and the Third Circuit certainly don't engage in a plenary review out the gate of the entire arbitration record. That plenary review is restricted to the district court. In other words, all the Third Circuit is saying is we step into the shoes of the district court, we apply the same standard they do, governed by the FAA here. The FAA has similar rules on vacature and modification of the awards. They basically mirror the NJAA here in the state. So just to clear up that point. And it is true that in, I believe it was Metro Media, the court talked about focusing on the record as a whole when discussing whether or not, or the scope of review in vacature and modification of arbitration awards. However, that was set in the context of the deferential standard. And more importantly, that record review, that review as a whole, only comes once a party rebuts the presumption of validity. Metro Media, the court makes clear, how do we rebut that presumption? That beginning, that starting point for all arbitration awards. Well, it has to be more than just an ambiguity in a written opinion. It has to be obvious error in the opinion itself. And once you've reached that point, once you can look at what the arbitrator said and know with confidence that they got it wrong, or that there is some obvious issue with their decision, then and only then do we peel back the veil and start to look at the record. And indeed, in Metro Media, the court resisted the urge to peel back that record. And it only looked at the arbitration award itself, the opinion from the court, and then the party's underlying submissions once it was certain that there was some issue at hand.
Any daylight between the standard of Metro Media that you're talking about and the two-stage aspect to this and Trentina and the Chief Justice's concurrence in Perini? Is there some distinction between those two?
Well, I think in Perini, the focus was chiefly on the vacature standpoint. Now, as my colleague did previously mention, there is some discussion in Perini about the modification aspect of the statute as it existed at the time. Metro Media and Brennan focus heavily on the modification standard, which is, it is its own creature of statute, but it again, highly deferential. And
is Metro Media also focused on the exact same statutory provision for modification as it exists right now?
Well, the language in that case dealt with whether or not they exceeded the authority, the scope of authority that they had under the arbitration agreement. Really, Brennan's the big issue or the big case in the Third Circuit that discusses modification. That's the one that we cite too. That one's heavily grounded in the modification statute in the FAA.
Correct, but I'm talking about NJSA 2A:23B-24. Are you saying that the language is identical to the FAA, and so we don't have to pay attention to our statute because the case is analyzing the exact same words, or do we have to analyze the words of our statute and how it's talking about the specific three instances for when modification is allowed?
I think we mentioned in our briefing that Consistently, New Jersey courts have sought to synchronize or find synchronicity between our NJAA and the FAA, and that they will turn to federal case law as well as federal statutes on arbitration when understanding, interpreting, and implementing our NJAA. So our position is that any distinctions or differences that they have, we still look to federal case law when we are trying to decide or interpret or understand, implement, or employ our NJAA. It's still relevant and persuasive authority.
So is your colleague wrong to be relying primarily on the state case law?
No, because the arbitration agreement in this case specifically said we are relying on the NJAA.
So why is the federal law relevant at all?
Because I think it ultimately does inform the court's decision to the extent that it is persuasive authority, and the court in the past has always looked to our federal case law for guidance with respect to how to implement our NJAA. Oh, any other questions? I didn't know if I saw anyone. But fundamentally, stepping back from the issue of any mischaracterizations of Brennan or Metro Media, our federal courts have given us a groundwork or given us a guide for how to implement the presumption of validity in our cases. Ultimately, it begins with looking at the opinion, judging whether or not there's obvious error. And then, as done in Brennan, if there is some question as to obvious error or obvious issues within the opinion itself that may underlie or undercut that presumption of validity, we then turn to the arbitration agreement itself, parties in this case created willingly and consensually, or their submissions to the arbitrator, namely in the form of any amended complaints or any complaints, court documents that were ultimately submitted that may contain or reference or in some way inform the scope of the arbitration. Here, we didn't do that in the Appellate Division. Here, we leapt straight to jumping into that record and trying to find as much difference and distinction as humanly possible between the findings of the Appellate Division and the findings of the arbitrator. And our whole point in our briefing is that ultimately we need to have a process that preserves the finality that is inherent and necessary to arbitration. And we feel that the federal process, at least with respect to modification statutes, is the ideal solution to this problem. The court has discussed time and time again the need for deference in arbitration review. The federal courts give us a guide on how to actually implement that deference. And we rely on those cases and highly urge the court to adopt that method for arriving at review. Lastly,
in that regard, are you raising an issue urging the court to adopt the federal structure to this inquiry that was not raised by the parties?
we feel that implicit to the parties' arguments is the need to define the standard here and how it operates. We believe that at its core, there seemed to be some disagreement or some confusion in the Appellate Division on how to review this case. And this is an opportunity for the court to clarify how that process looks. Our goal here, whatever the dispute ultimately is between the parties in this case.
Let me ask you the question again. Was that issue raised by the federal standard that you were urging the court to adopt raised by the parties?
Oh, I understand, Your Honor. No, it was not raised by the parties in this case.
And indeed, in the arbitration agreement itself, at paragraph 2A, they're quite specific about the New Jersey law.
Yes, New Jersey law does govern. They made it very clear the NJA does govern. But again, I urge the
There's
court.
some specific issue with New Jersey law here. It's not clear to me why you're disagreeing with the statute. It seems like it's very helpful to your position in that it says that modification can only be made in 3 very specific instances. So are you saying that there's some problem with the New Jersey statute and that's why you like the federal approach better, or that the federal approach is just an additional gloss you're adding to the case?
I would agree with the second point. It's additional to the New Jersey statute, but really what the federal case law here is how we implement that New Jersey statute. When you're applying the modification statute and you're reviewing under it, how that review is supposed to look. That's where we're highlighting the federal case law. Because in that case, specifically in Brennan, it gives us a step-by-step on how to implement the modification statute. And that's where we think.
Yeah, I think we have your position with respect to that, but having covered it already. Is there anything in addition you'd like to present?
Just a last point, Your Honor.
Please.
In the supplemental briefing, I believe NJCJI's concerns were described as wolf cries, and that there was no evidence that parties that businesses in the state of New Jersey would feel less inclined to engage in arbitration or rely on arbitration based on the results of this case. New Jersey Civil Justice Institute's members sent me here today specifically because they have deep-seated concerns about the viability of arbitration here in New Jersey. There is a perception of longstanding hostility in the legislature, both national and state, as to the continued practice of arbitration, whether it will continue to be protected under statutory law. There have been abuses in the arbitration world, such as mass arbitration, which I'm not sure if the court is familiar, but has made it very expensive for many businesses to have arbitration provisions.
Aren't we getting a little afield from this case?
Our point
It
is,
seems like arbitration is thriving in New Jersey.
but our concern, as our members' concern, is that fundamentally it's making arbitration less reliable as a tool for final adjudicate or final justice. That's our chief concern. Our members have come forward to remind us of this fact, that they are considering whether or not arbitration is still viable for how they arrange their liability here in New Jersey. We're talking about potentially billions of dollars in liability that are now covered under arbitration agreements here. And if we erode the finality aspect of arbitration, it causes businesses to question whether they can rely on it as a form of alternative dispute resolution, as opposed to just a springboard to more litigation. That seems to be what we've arrived at here in this case. Arbitration here was just the first step in more litigation, which is what we've been reminded by courts, including Justice Valance, or Chief Justice Valance, was never the purpose of arbitration. It shouldn't be the first step towards going to court. It should be the last step, with very limited opportunities for review to preserve the finality of the process.
Thank you, Mr. Daniel.
Thank you very much, Your Honor. Chief
Mr.
Justice.
Nusifar.
Good morning. May it please the court. I'm going to spend the first few minutes speaking about some of what I believe are the inaccuracies to the factual record before you that was articulated by counsel. But what I first want to do is put in context how we got here and how this started. Mr. Rappaport is one of the founding members of the CABR entities. He is actually the R in CABR. He was there at the beginning. He invested money and years of service as a member and as an employee of the CABR entities. He was wrongfully terminated. It was decided by the arbitrator in bad faith by the bad actors, and was awarded $4.9 million in wages, essentially front pay and back pay, for the benefits he would have been paid as an employee. It had nothing to do with his equity membership in the entities. How do we know that? Because at least 5 or 6 times that I can give you examples of, the defendants, the bad actors, disclaimed it at every single portion of the arbitration. And I'd like to give you a few examples of this and point to the record. The first disclaimer example is defendants' opposition to the initial order to show cause. So we had 5 operating agreements. And they all had generally different arbitration provisions in them. So under the law, the New Jersey Arbitration Act and the New Jersey law, we were allowed to go in on order to show cause for emergent relief to stop what was happening and not happening. They kicked Mr. Rappaport aggressively out of the office that day, shut off from all financial information. He was the CEO of the company, and he was also a member. In most of the memberships, a 35% membership interest in these entities. So we went in and said, wait a minute, to Judge Juragian in the Chancery Court, this needs to end because we ran the company for 10 years. We have investors. We know the daily operations. I'm the right person to do this. We then agreed to go to arbitration. And Mr. Rappaport won the arbitration by all accounts. He was given $4.9 million minus $1 million for a set-off and a counterclaim for his salary, but walked away with no membership interest. This had nothing to do with his membership interest. So the first time that the defendants, by the way, what happened after the hearing? They issued distributions for carried interest, and they took it, excluded Mr. Rappaport, a membership distribution for carried interest, and put it in their pockets. So what is the lesson learned from that? How could we allow a membership to take one of its members, its founding members, kick them out and say, oh, your equity is gone too, even though you can't do that under the operating agreements or the LLC statute without fair value paid. So let me get back to the disclaimers because I'm getting ahead of myself. The first time they disclaimed it was in their opposition to our initial order to show cause that I just explained. And that was back in April of 2019. The very first submission to the court under sworn testimony, they wrote, and this is plaintiff's reply appendix PRA 33. Defendant's brief in opposition to Rappaport's order to show cause on page 33 of the brief states, quote, Rappaport's removal as an officer has nothing to do with his status as an equity owner. There's another example in those papers. Plaintiff's reply appendix at 15, PRA 15. Defendant Adam Altman certification quotes, the members voted to remove Rappaport as an officer on January 29th, 2019. Rappaport's compensation has been unaffected and he maintains all of his economic rights. There's another certification by Mr. Pasternak, and this is at PRA 3 as well. It states, defendant Kenneth Pasternak's certification since his departure, quote, Rappaport's compensation has been unaffected. He was paid in timely fashion and maintains all of his economic rights. Those were defendant's first submissions to the court. The second disclaimer example, after the parties entered into the arbitration agreement, after the arbitration agreement, and the parties submitted the claim and counterclaim. So what we did is we submitted our claim in the order to show cause as our claim document. They put more together like a 5-page summary. And in that claim, it states, defendant submit, there's absolutely no claim for disassociation, redemption, or for a buyout, or divestiture, none. And in fact, the Chancery Court made that affirmative ruling at that level when we were moving to confirm. The Chancery Court specifically said, I have reviewed these claim documents very thoroughly, and I cannot find a claim for divestiture, disassociation, redemption, or buyout. I would submit that under the statute, that once the court found that, it is a compulsory statute. NJSA 2A23B-24A 2 states that one of the options to modify or change an arbitration award is that the arbitrator made an award on a claim not submitted to the arbitrator, and the award may be corrected without affecting the merits of the decision upon the claim submitted.
On the first prong of that the arbitrator made an award on an issue not submitted to the arbitrator, can you submit a motion in limine before the arbitration started? So there's no testimony. Motion in limine seeking dismissal of defendant's counterclaim as well as declaratory relief that your client was a fully vested member of the KABR entities under the operating agreements and was entitled to future carry regardless of whether he remained a manager or not.
So the in limine motion was submitted on the same day that our pretrial briefs were due. And we read their pretrial briefs. And for the first time, they were making the claim that the operating agreements were invalid and unenforceable. Now, they were later determined to be absolutely valid and enforceable by the arbitrator. And it was funny because in the trial court and the order to show cause, they were saying that the operating agreements are enforceable and the arbitration agreements are enforceable. But then the weeks later, they're taking the position that it's not enforceable because in the operating agreements.
Did you file that in limine motion? That was representing your client's position at that moment in this arbitration.
We filed about a dozen in limine motions.
I get it, but I'm not, with all due respect, the other 11 are not central to this. Did you file that in limine motion?
We filed the in limine motion, but it did not address carried interest. It addressed that our client was vested in the operating agreements because his management fees, which how he was paid his compensation for an employee, was within the operating agreements.
Do you dispute the contention on the other side of the room that the Appellate Division attributed remarks to the arbitrator that were actually direct examination of your client.
Are you talking about the colloquy that's cited within the?
Yes.
Yes. So I would argue that it was a Scrivener's error in that it was us asking the questions at the
But I
time.
mean, is there any question whatsoever that what the Appellate Division thought was a sua sponte raising of the carried interest issue by the arbitrator, thus in the Appellate Division's view, injecting an issue that was not previously there, was actually, I don't want to say it's you personally, were you doing the direct?
I was not.
Or not? It was counsel for your client doing a direct examination, and it was your side that was asking the questions that were attributed to the arbitrator. Is that true?
That is true in the colloquy, but I would argue, Your Honor,
Okay,
the-
it is true that the Appellate Division, for whatever reason, I'm sure an innocent error, attributed to the arbitrator statements that were actually made in direct.
that is accurate, but I would say that the spirit of what the Appellate Division was stating and relying upon is exactly the same, and that has no effect whatsoever on the substantive decision of the Appellate Division.
But there were other spots where there was an affirmative ask on the part of your side of the aisle for carried interest in the form of the post-hearing briefing, in your proposed arbitration award. Both instances, you asked for carried interest. Why then was it inappropriate for the arbitrator to award?
I'm glad you asked that question because it's very important. I'm going to go back to that. There's no claim document that asserts a claim for divestiture, disassociation, redemption, or buyout. Okay. During the pendency of the arbitration, the arbitrator did start sua sponte asking questions, and it's right in that same colloquy. And that's why on direct, we were clarifying that the damages being sought were not carried interest. They were management fees, which how he was paid his salary.
So are you saying that the arbitrator raised the issue of carried interest first within the arbitration and you responded to that, even though in questioning that you've already responded to from Justice Weiner after you acknowledge that you filed a motion in limine with regard to carried interest
So
prior to the arbitration?
we filed an in limine motion, not asking that we're entitled to carried interest. It's that we were vested in the operating agreement, which because there was a vesting schedule within the operating agreement. We weren't asking to be paid carried interest. We were asking to be vested in the operating.
But are you arguing that the arbitrator raised carried interest first during the course of the arbitration?
As I sit here, I say that carried interest was not a claim in the arbitration, whether or not it was sometimes discussed within testimony to clarify what damages were being sought. Yes, it was raised.
But can you
If it wasn't a
just
claim, what-
clarify on page 183 of the transcript, PA 1440, the question is asked, with respect to this litigation, or rather this arbitration, are you asserting any claims with respect to your carried interest? Answer, I'm asserting the fact that I am entitled to that and I am fully vested in the carried interest. The Appellate Division attributed that to the arbitrator,
Correct.
but it appears that it is asked by the counsel directing this examination. So which is it?
So, Your Honor, it is incorrect what the Appellate Division cited. That line of questioning is in response to the sua sponte colloquy that's right before that raised by the arbitrator.
But the substance of it is that they are in fact asserting a claim for carried interest.
No, we
Isn't
were
that
asserting,
the question
I'm
that
sorry, I didn't mean to respectfully,
Okay.
I thought you were done.
Doesn't that resolve the question we're trying to get to the
No.
bottom of?
No, I don't believe it does respectfully. That is saying that he's vested within the carried interest, which he was, because remember, they're taking the position for the first time on the eve of trial that the operating agreements are invalid. And we were arguing that they're valid and he's vested. You cannot just throw a member out.
You're saying, I'm sorry, that he's vested with regard to the carried interest. So even if you might not have been arguing, this is how much my carried interest is worth on X day, and I want this sum of money today, you were requesting a declaratory judgment that he was vested and would continue to receive carried interest in the future. And the arbitrator refused to provide you with that over and over again, despite the fact that you kept requesting it. So how can we say that this issue was not before the arbitrator when you kept requesting, all I want is a declaratory judgment that says that I am entitled to receive carried interest in the future as it is paid out, and the arbitrator says, no, 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 no.
So the equity, the carried interest is within the equity of the company. There was no claim to remove him. So just because you make a declaration, and we argue this in our briefs, that we're entitled to it down the road, we acknowledge that it wasn't even due yet, so we couldn't have made the claim. The claim didn't arise until after the fact, when the arbitration was over.
But wasn't it part of the arbitration agreement that was with respect to the dissolution or disassociation of Rappaport from KBR?
I would agree with you. And this is where we talk about arbitrability, if I said that right, versus what was submitted before the arbitrator. We agree that if there was a claim brought for disassociation, divestment, divestiture, redemption, or buyout, it would be an arbitration. We believe it would be. It just wasn't before him, because if it was, all of the things that the LLC had to do
But the
pursuant to the statute.
The flip side is that it is within, I mean, do you dispute that the general topic is within the scope of the arbitration as described in the arbitration agreement?
I would say that once we were on notice that Mr. Rappaport was being disassociated from the membership as articulated by the arbitrator, that we now have to go back and arbitrate or agree upon what the value of that membership interest is. He was terminated as a member. If you look at as an employee.
But let me ask you a very simple question.
Sure.
Was this an arbitrable issue under the arbitration agreement?
It is an arbitrable issue under the yes, we can
Okay, so
see
that's
that
my
if it
simple
was
question.
brought, it would have been arbitrated.
So,
And you've gone beyond that to, I'm sorry. let me
no, you
interrupt.
go ahead, please.
You've gone beyond that to say this was not a claim you advanced or a claim in front of the arbitrator at the very same time, as Justice Winter-Apter pointed out, that you specifically asked or asked for a judgment noting your entitlement to carried interest.
So-
How
so-
do you square those two?
Yeah, and that's a good question, Your Honor. What are you, I know you see you're pointing to a document. I'd like to address the timing,
I'm looking at the very end.
the very end of the arbitration. Because at some point in the arbitration, including at oral argument for closings, which were done by phone because we were heading into COVID at that point, that's how long ago we were talking about this. The entire oral argument by counsel was that he was not entitled to, it had changed. So we asked the court to address that. And we did that in our closing.
Flip it around. And I know this is a very difficult question for you. Had you prevailed, had the arbitrator given you what you had asked for and the roles were flipped, I imagine it would be rather difficult for you to argue this issue wasn't in front of the arbitrator. How would you respond to that?
No, I would say it's very easy. In fact, if I were allowed to, I'd like to go through some of the other what I say are inaccurate sites of the record, which show it wasn't before the arbitrator. And they told us the entire time, including after we submitted. And I think I should go right to it, Your Honor.
Are you telling us that had you prevailed and the arbitrator awarded you $25 million for carried interest, you would concede to your adversaries if they were challenging and say, well, it wasn't in front of the arbitrator?
Your Honor, it's a very difficult perspective to put in, but I've been practicing law for 25 years. And I'd like to think that if it wasn't before the arbitrator, that I would literally have conversations with our client, who's a very reasonable businessman, and say it wasn't for the arbitrator. We certainly didn't place it for the arbitrator.
You wouldn't be relying on that direct examination Q&A, which at that point would be gold, saying, are you making a claim? And the response of your client in the presence of the arbitrator that they were.
I cannot in good faith sit here and tell you that I could do that because it wasn't. I cannot. I'm not sure how the other side could take that position because we've things that I don't really want to say at this point.
It's hypothetical and difficult for both sides.
Yeah, it is.
The black and white problem that we face is you made pointed requests for carried interest. And At the same time that you're arguing it wasn't in front of the court,
Well,
of the arbitrator.
It wasn't a claim in front of the court. It's not something that wasn't discussed. It's almost impossible because remember, our expert had a damages model and asked in his testimony if there was any carried interest in it. He said no, because it wasn't before in the arbitration. Their own expert, which was an in-house, I think it's a CFO, Mr. Goldstein, when asked, are there carried interest or equity member valuations in your damages model? He said no, because it wasn't a part of the
Around
case.
the clause in the arbitration agreement, the scope of the arbitration.
Yes.
That referred to any claims that could be asserted by any party as part of the claim or counterclaim. Are
Yeah.
you actually telling us that in this very broad claim and counterclaim, that in the litigation that was eventually suspended or dismissed in favor of arbitration, you could have not have made a claim for carried interest for, even if that claim were he should remain as in his position as an equity owner, and he should get all the benefits of that?
I'm not sure I'm understanding following the exact question.
How could carried interest be outside of the description in the arbitration agreement that any claims that could be asserted by any party as part of the claim or counterclaim?
It's outside because it wasn't asserted in the claim document. And that was found by the Chancery Court.
It says there is language that what was in the claims, but there's also this language that said any claims that could be asserted by any party as part of the claim or counterclaim.
Yeah, we absolutely agree with that language. That could have been asserted. That's like a slip.
Could have been. You're saying that carried interest could have been asserted.
I would say that the arbitration agreement would cover a divestiture or disassociation claim if it was brought.
You're
As we
saying
sit here
this
today,
refers to a claim that is brought in the future
it is because
after the arbitration agreement was signed, and not necessarily anything that could be brought, but might not be.
yes, Your Honor, and to try to put it in a perspective that I can articulate it better. If it was a slip and fall, right, and that language was, and a slip and fall could be covered under this arbitration agreement, and someone had slipped and fell after the arbitration, then it still would be covered by the agreement. It just wasn't brought at that time because it could have been.
But you just said it could have been. Now, and if it could have been, then likewise, you could have submitted an expert report attempting to prospectively value the assets, couldn't you?
If we were on notice that they were going to, we divest or attempt to disassociate Mr. Rappaport, yeah, we would have.
But you were on notice that it's called disassociation or dissociation in different places.
Correct.
But you were on notice that disassociation was in issue, as well as resolving every other claim so that there could be finality. So I guess why didn't you then, especially considering that you answered the question, are you asserting a claim for carried interest? And the answer from your client was yes. Why didn't then you just try to value it and put in an expert report valuing it rather than relying upon an ambiguous, well, I think it's about $25 million?
Well, because it didn't arise until that testimony. But what I would say is
Which testimony? The testimony.
the testimony that
Claim. Okay.
Justice is speaking about, where we
Won.
Where your client
you-
testifies, yes, I'm bringing a claim.
No, I don't. With all due respect, he testified that he was looking to be acknowledged that he was going to at some point in the future be due carried interest. So as a part of his membership interest, because remember, this is part of his membership interest.
What did he actually
So
say?
he's looking to be acknowledged that at some point in the future, he's entitled to carried interest. But the arbitrator keeps saying, no, I will not acknowledge that. No, I will not acknowledge that. No, I will not acknowledge that. How is that somehow not before the arbitrator?
I think that's why we're here. It wasn't a claim before him. It wasn't
But it was a request from you.
it wasn't
Or it was a request, I'm sorry, from your client's attorney at the time.
No, we were their lawyers. I just didn't do that portion of the direct. I did the entire the other 13 days, but it was a request clarifying the sua sponte colloquy of the judge.
Here's the Q&A, and then perhaps you can respond
Yes.
to it pointedly. With respect to this litigation, or rather arbitration, are you asserting any claims with respect to your carried interest? Answer: I'm asserting the fact that I'm entitled to that and I'm fully vested in the carried interest. You're telling us this is not a claim that you were advancing.
No, it's not a claim. It's not in any of the claim documents. And the reason is because they are complex agreements, but there's a vesting schedule. And after 2, 3, 5 years, you're then vested in carried interest, which is an equity part of your equity membership. And he was
He was
saying
not entitled to it that day.
he wasn't entitled to it that day.
So, but he is saying, I am asserting that I am entitled to carried interest on the first day of the arbitration in a direct question that sounds like a perfectly appropriate clarifying, let's tell the arbitrator what's before him. And he says yes. So I respectfully suggest you're in a difficult position by saying that the arbitrator made a mistake by concluding that carried interest was in the arbitration.
Well, I don't think we're saying he made a mistake. We're saying he ruled on an issue that wasn't before him. He disassociated Mr. Rappaport from a membership. Remember, these are billions of dollars in real estate that they managed. The carried interest portion, what's in their ownership, is the big money in these relationships. So at the point after 10 years of all this hard work that they're going to start paying off, they kick him out and say, not only are you fired, but now you're no longer a member.
Can you point us in the record to the arbitrator's colloquy that you mentioned was why plaintiffs and plaintiffs' counsel at the time asked that question? You said it was a clarifying question with regard to the sua sponte colloquy from the arbitrator. Exactly what language are you arguing that the arbitrator stated, and that is the reason why plaintiffs and plaintiffs' counsel at that time engaged in that conversation?
Your Honor, yes, we can get. I don't have that in front of me at this moment. We can pull that and we can give you the. Yeah, I apologize for that. We can do that, but I want to point to some other disclaimers, because I do hear a lot of questions of that colloquy, which I would submit that even that colloquy doesn't give us notice that we have to prove out a claim of what our membership value is.
But didn't you make that precise argument during your closing argument? So during closing argument, you say to the arbitrator, Rappaport is entitled to the profits and losses of the management company, including the carried interest, regardless of the termination or separation or any reason why you may be terminated when it comes due in the future based on the language of the operating agreements, and that depriving Rappaport of that carried interest would violate due process because it wasn't an issue before arbitration and it wasn't raised in the pleadings. And that's all part of the closing argument. And the arbitrator still says, no, you are not entitled to future carried interest. This 4.9 million represents a fair award under all circumstances for both your rights as a manager and your rights as a member. So how can we say that was not before the arbitrator when you were so clear in closing argument that you wanted the arbitrator to say, yes, entitled to carried interest going forward? And the arbitrator said, no, I'm not going to say that.
I think I just heard it. We disclaimed it there. It's not in this arbitration, but if they're saying that if you're going to disassociate us, then we're entitled to carried interest. And I said it right in what you had just read, Your Honor.
But the arbitrator disagreed, and the arbitrator held that it was before him, and that was certainly not manifestly wrong.
The arbitrator doesn't get to decide what's before him. The agreement doesn't allow for that. I know that's their position, but the agreement does not allow for that.
What agreement?
The arbitration agreement.
So where does it say it doesn't allow for that?
So if we take a look at the arbitration agreement, which is PA 197, it states that, well, I mean, I think what defendants do is they conflate the arbitrability on the one hand with the claims that were actually submitted. And, arbitrability is whether a pleaded claim is subject to arbitration or to a litigation prior to the commencement of the adjudication at issue. The case is not about arbitrability. We can see that if a claim was brought today, to disassociate that it would be in arbitration. Defendants point to the arbitration agreement provision to infer that the arbitrator was the sole adjudicator of whether a claim was submitted before arbitrated under the NJAA. The arbitration agreement stands for the opposite
So do you
proposition.
concede that the arbitrability provision, which is the term I'm using for the couple sentences beginning with, or it's one sentence, the scope of the arbitration ending with KABR management companies, that paragraph. Do you concede that carried interest is within that paragraph?
I concede that if a claim, and I'm being careful with my words here because I want to make sure it's accurate to the claims that were asserted. If there was a claim for divestiture, disassociation, redemption, or buyout, it would be subject to the arbitration agreement.
What about the fact that the arbitration agreement specifically incorporates the commercial arbitration rules of the American Arbitration Association, and 7A of that provides, quote, the arbitrator shall have the power to rule on his or her own jurisdiction, including any objections with respect to the existence, scope, or validity of the arbitration agreement, or to the arbitrability of any claim or counterclaim.
I think we're talking about arbitrability again, that not what was actually submitted to the arbitrator. And
The first part of the clause, the arbitrator shall have the power to rule on his or her own jurisdiction.
yeah, this is, I wouldn't say this is a jurisdiction issue. This is an issue of what was submitted before him.
So you kept saying before the arbitrator, this wasn't submitted before you, and the arbitrator kept saying, yes, it was, and I'm including it in the award. And it seems like that's pursuant to the AAA rules, that the arbitrator can decide what is or is not before him.
Well, I would say that the agreement mandated the parties submit claims and counterclaims, specifically identifying the claims, issues, and damages they were seeking the arbitrator to decide, as the agreement required the parties to follow the NJAA.
So how do you get around the argument that says, in addition to what is in the claim and the counterclaim, that the arbitrator, the scope of the arbitration includes, quote, any claims that could be asserted by any party as part of the claim or the counterclaim? That's pretty broad language.
It what could have been, and they weren't asserted. Otherwise, there would have been. So
Could have been. So you got two categories here. Tell me if I'm wrong. You've either got what's in the first clause to confine to adjudicating a claim, counterclaim, and related matters. Okay, leaving aside whether that includes this. You got this later provision that says any claims that could be asserted by any party as part of the claim or counterclaim. If what you're saying is it was arbitrable, but it wasn't asserted in the claim or counterclaim, aren't you defeated by that later clause that says anything that could have been?
no, because it wasn't ripe yet. If there was a dispute in the partnership, and this happens all the time in the members, where the members are fighting over something, right? And this happened to be that they threw Mr. Rappaport out as an employee. That doesn't mean that the membership interests go by.
And you say it's not right. You have claims all the time that you have to bring in an expert to value the claims because they're not yet, you're dealing with future estimates of the value of that claim.
Our position was that we should be back in there operating this company, not that it should be disassociated.
But you might lose, right?
What's that?
You always have to consider the fact that you might not be restored to your position as an operator.
And in fact, the arbitrator ruled that he shouldn't be back as an employee, but said he was wrongfully terminated as an employee, not as a member, because you cannot be terminated as a member under New Jersey law or the operating agreements. So he was kicked out of a membership without being fairly paid the value of that membership interest. There are two different sets of damages for two different claims. We won the claim that he was wrongfully terminated in bad faith, but that doesn't mean he just gets kicked out of a membership and his entitlement to what that value is, and the carried interest, which is the biggest payday, because they won that he was not going to be back in the offices operating the company. You can't do that under any law in New Jersey, not the revised LLC statute, not the operating agreements, which clearly doesn't allow that to be done to any member. This is a protection that why people enter memberships is to make the money and to be protected.
So it sounds like then that you're arguing that the arbitrator committed an error of law, because even if someone is wrongfully terminated, they cannot be taken out of the out of the corporation and their carried interest in the future, their right to it cannot be taken away. But under our scope of review of arbitration decisions, specifically the Chief Justice's concurring opinion in Perini that's then adopted by a majority of the court in Trentina, doesn't it specifically say whether the arbitrators commit errors of law or errors of fact should be totally irrelevant? The only questions are, were the arbitrators honest and did they stay within the bounds of the arbitration agreement?
So I would say, yes, the arbitrator did make errors of law. Clearly.
But we don't get to review on that.
I'm not asking that here today, though, Your Honor. I'm not asking that. I'm asking this court to adopt the Block versus Plosia and the Siri Pompa, which is a fantastic decision by former Justice Timpone, that is exactly what this case is. And I would argue that if there's any case that this court should look at of why this statute was promulgated, and I mean NJSA 2A:23B-24, is because of this case. Okay, it states that the court shall, it's a compulsory statute, shall, if the arbitrator made an award on a claim not submitted to the arbitrator. There is no claim. If there was a claim, it would have been explicated in the claim document, and those damages of Mr. Rappaport being disassociated, divested, I know I'm sorry, I'm keep going with this, redeemed or bought out would be in that claim. How could he just walk away after all these years of service of putting all this money in the company and they say, yeah, you were terminated in bad faith, but we're going to keep all the equity membership. That's why it wasn't part of the claim.
Can you help us read the scope language in the arbitration agreement alongside of the proposed arbitration award in this regard? Your argument has been that the scope includes any claim that could be asserted, but that neither party actually asserted it, if I understood you correctly.
Yes,
and looking at the proposed arbitration award that you submitted, you asked for both a finding and an award in the form of a declaratory judgment that you are entitled to carried interest. Okay. With respect to the proposed arbitration award, was there qualifying language along these lines? This is not in front of you, arbitrator. This claim is not to be ruled upon, but if you reject that argument, this is what we're asking for. Was that part of the proposed award that you requested from the arbitrator?
So I want to put the proposed reward in perspective. That's nothing that we ever agreed to, but one day as we're sitting in our offices, we saw the defendants submitted a 50-page proposed order and summary. So we, of course, went to the arbitrator and said, this entire document was not agreed to. We only agreed to post-hearing briefs and oral arguments.
And correct me if I did this incorrectly, I was reading from your proposed arbitration award.
Yes. So this is where, so we actually had another conference with the arbitrator, and he got us on a call and said, yes, he said, counsel, I don't even look at these things because they're advocacy pieces. But Mr. Yusufora, you sound a little upset because you didn't agree to this and you got this. So you could have a chance to respond to it. So of course, what we did, now this is after all of these hearings,
yes.
After that we said, okay, if they're saying we're not entitled to it, Your Honor, we're entitled to it. We don't know the value of it yet.
But when you propose, I'm sorry, Chief, go ahead.
No, but did you say, Judge, this is not in front of you?
Absolutely.
Or, no. Or did you say, Judge, give us this award in the proposed arbitration in the response that you generated?
Your Honor, I said both. I said, this is not before you in every response.
When did you say that?
In every response I've ever submitted, including the in limine motion.
Where in the record does that exist?
I have disclaimed throughout the entire record. It's well cited in our brief every single time. But I want to that point, and thank you for raising it. I'm going to go to what could be the most seminal document in this entire litigation or arbitration. It was the joint issues of the joint stipulation of legal issues before the arbitrator. That's at PRA 38 to 40.
And that was before your proposed award.
That was around the same time, Your Honor. They were all being submitted at the same time.
The end of
but
after the arbitration.
After the arbitration. So after the arbitration, the arbitrator said to us, counsel, come up with all of the issues before me, and I want you to agree on them and submit it to me so I know what I'm ruling on. There were 20 of them. 20. Again, this is at PRA 38 to 40. There are 20 of them. We negotiate them for days. There's tons of emails back and forth, phone calls, Zooms, you name it. Not one of them states that this was looking to divest, disassociate, redeem, or buy out Mr. Rappaport from his interest. I don't know how it gets further than that, along with all of the other issues in the record.
Does that statement of issues include that he would maintain his position as an investor?
No, that was never an issue. That was never an issue.
Questions? Counsel, is there anything else you'd like?
Yes, I'd like to address one issue, Your Honor.
Colleague wants you to respond to an earlier
Yeah, we
question.
have- So I'm going to direct to the court in response to the question about the direct testimony of the sua sponte questions. And actually, the arbitrator said this is sua sponte and not determinative how. But it's on page, it's PA 1436. And it's on page 167 and 168.
Sorry, but that still starts with, I think I've read that whole colloquy and I see where the arbitrator asks questions, but it seems like it starts with a question from counsel. What do you understand after December 1st, 2016, an original member of KABR 3 would be entitled to receive, and then Rappaport, he would be entitled to receive 100% of whatever his interest was in 4.2, which is basically him explaining what carried interest is. And then counsel says for how long, and Rappaport says forever. So it seems like it starts with what is someone entitled to receive, carried interest forever, before the arbitrator asks anything.
I understand, Your Honor, but you have to remember, just for perspective again, we are at trial. We're laying a foundation and factual background of what the different types of compensation he receives. One was wages, which that's what we're discussing, but he also was a member, and we're not seeking that membership interest because there is no claim for it. But we still had to set a foundation of what we were seeking because we had an expert who said, this is what we're seeking in terms of damages. Those are just foundation questions. I can't imagine that that we can have a rule and that could say that if you raise in a sua sponte question the issue of your membership, that it could be taken away. That would, to me, I can't imagine talking about the chilling effect on arbitration. You're basically wiping out any party, individual who would ever go to arbitration because an arbitrator can literally do whatever he can and take away membership interest.
Counsel respectfully was dealing with a very broad scope of arbitration in a negotiated arbitration agreement to begin with. And there was clarification that, and several points, and I won't rehash it, we're late in this argument. There's several points at which you raised this, your client raised this issue of carried interest with no, as the chief was describing, disclaimer saying this is off the table, Mr. Arbitrator, but we're still going to talk about it. It is raised as an issue, and when you get down to the proposed arbitration award, you're asking for an award to win on this issue.
It was a responsive document, Your Honor, but what I would say is we disclaimed, and the Appellate Division did a great job in showing where we disclaimed it from the beginning to the end. In our oral argument, in our closing argument, we said this is outrageous. This is not before the court. We did that from the beginning in our in limine motion. In that motion where we say we're vested, we say there's no claim, but we want the declaration that we're vested in the operating agreements. So we disclaimed it. So there's been a lot of tension on what we did, but I just want to turn for 1 second. I know we're getting late and I appreciate the time to be, and it's an honor to speak before you, but if you could bear with me for a minute.
Happy to bear with you, and then I'll ask you to wrap up your argument as you.
Absolutely. And so the difference of the disclaimers that it was not the claim for disassociation was not before the arbitrator, was again and again right through the end of the arbitration stated on the record. So the third disclaimer was in their pre-hearing brief. In their pre-hearing brief, which was 4 days or 5 days before we started, we opened, and this is at Plaintiff's Appendix 1904. Defendant's pre-hearing brief reaffirms this case has nothing to do with Rappaport's equity membership. The quote is from their brief, here, plaintiff's removal as an officer, it has nothing to do with his status as an equity owner.
Is
End
that
quote.
the same as saying that the equity owner, this has come up a number of times in the briefing and also today, that his status as a manager is distinct from the status as an equity owner.
That's right.
That seems to me to be very different from saying from a disclaimer that says, Chief Justice, Mr. Arbitrator, you should not consider the equity owner. Saying that the two are distinct and separate can mean a lot of things. It seems to be factually true, but that's not the same as saying don't consider any ramifications of his equity ownership in this arbitration. See what I'm saying?
Well, the carried interest arises from their equity ownership.
I get it.
So I think
I get it. But when you say that the status as a manager is different from the status as an equity owner, is very different from saying don't consider anything in this arbitration that deals with his status as an equity owner.
there were no claims to address his status as an equity owner. That's correct.
Where did you say that?
I said that in every document that we submitted before this court. In every one. We've reserved our right to that from the minute it was raised right into the end. We've raised it even in our closing.
You reserved your right to the value of his equity ownership
And that's what we're talking about today, Your Honor. That's what
before
I
the
said.
arbitrator.
No, I raised that it wasn't an issue before the arbitrator.
And that was not in the arbitration agreement.
I'm sorry?
Your disclaimer was not specifically addressed in the arbitration agreement.
The disclaimer
Right.
was not. I don't know that I'm following the question, Your Honor.
Well, you talked about all of these disclaimers, that it was never an issue in the case. But the arbitration agreement says any claims that could have been raised would be. So in that agreement, did you say any claims except for carried interest?
No, because we would agree that if there was a claim to disassociate a member, it would have to be arbitrated because we agreed to it. It just wasn't at that time because there was no claim. Because if the LLC statutes and the governing law doesn't allow for a member to just be kicked out without a claim and the payment of fair valuation of the membership, not his wages, of the fair value of his membership, which is exactly what we're talking about here.
Counsel, I think we have your position. Is there anything you wanted to add to close out your argument?
I believe that is it, Your Honor. Thank you very much. Appreciate it.
Mr. Shu, brief rebuttal?
A few quick points with regard to the argument that the arbitrator only granted an award on wages, but nothing on membership interest. That's belied by the specific language of the arbitrator's last decision, where it was sent back to him on remand to clarify whether his award was simply for the management fees or also for membership. And he clarified that it was for both. So it was not just wages. Secondly, the Appellate Division decision itself acknowledges that the disassociation claim was properly before the arbitrator, and it did not vacate that decision. The only reason that it modified the award was because it misread the record by making an error with regard to who the arbitrator sua sponte raising the question when it was really Mr. Rappaport and his attorney on direct. Now, I would invite the court to review the full transcript because the arbitrator did not inject the issue of carried interest into the proceeding.
Counsel, could you respond to the argument about the joint stipulation of legal issues and what is and is not in there?
Yes. the joint stipulation discussed the breach of contract claim, the breach of fiduciary duty claim, the minority oppression claim. It's our position that the compensatory damages that were sought included carried interest within the scope. And I would direct the court to PA 2075, which is page 974 of Mr. Rappaport's redirect, where he was asked.
2075?
2075. And he was talking about if any member is terminated without good faith, would they be in violation of the agreement? Yes. As a member, would you receive the profits and losses of the company? Answer, as a member, I receive just the profits and losses of the company. Question, would you also receive the carried interest? Answer, yes. And that's part of the profits and losses.
Is the language you're quoting for us now contemporaneous with the joint stipulation approximately? Are they?
Oh, this is after. This is part of the hearing itself.
Yes.
Where he's testifying. First, he testified that I'm seeking carried interest in the arbitration. And then he was asked questions about the operating agreement and what would be encompassed within that.
I'm sorry, I thought your adversary had said that the joint stipulation was after the arbitration. It was before or after the joint stipulation? of issues before the court?
PRA 38 to 40 we were talking about, or 28 to 30 perhaps.
I don't have that in front of me, but to me, it's irrelevant whether it was before or after.
You noted
Because-
that the arbitrator requested a stipulation from both parties listing all the issues that were before him.
Correct.
And that
That
you
it's the
worked
most
together.
important document in the whole record.
Yeah, that you worked together and went back and forth for several days or.
Correct.
some manner of
There
time.
was back and forth and there was a list, and the list doesn't, I don't believe
Before or
specifically,
after the arbitration that the list is submitted.
believe it was after.
Okay.
I believe it was after. But my point is that he did not inject the issue. The testimony of the plaintiff was that he was entitled to carried interest as profits and losses under the operating agreement. And when the list of issues was presented, it included what are the damages under the operating agreements. So that would include carried interest.
So that's on that list. I know you don't have it in front of you, but what are the damages under the operating
I
agreement?
think it's, did plaintiff satisfy his claims for breach of contract and breach of fiduciary duty? I believe there was a damages, but I would not represent that without looking at the list. But you don't have to take my word for it, because if you look at the record, I mentioned the plaintiff's request for clarification or reconsideration of the denial of carried interest, where he specifically says, and this is in the record at PA 1336, where he says, I'm entitled to carried interest under the operating agreements. I think the award, even though you denied carried interest, it was only as of that time, but really what you meant is I'm entitled to it going forward in the future. I'm entitled to future carried interest. And that's the undisputed testimony. So what he was saying is, I'm entitled to carried interest under the operating agreements.
So this was not testimony because this is all very late in the game.
This is
point.
after the list was submitted.
Argument.
This is after the first award, and he was denied carried interest. And he said, you can't deny me carried interest. You held that the operating agreements were enforceable. Those operating agreements that I claimed were breached and entitled me to compensatory damages. I'm entitled to carried interest under those operating agreements. So he was clearly saying, I'm entitled to this carried interest. I sued for it. I'm entitled to it. And I agree with you, Chief Justice, that if he had been awarded $25 million in carried interest, we would not be here today.
And you might be taking a different position as well.
We might be here today.
And I think that's it. Thank you very much.
Thank you. Thank you to all counsel for the very helpful arguments. We'll take the matter under advisement.